Ladies and gentlemen, I welcome all to my channel. Today we are going to discuss about a check bouncing case, that too with respect to the interim compensation payable at the time of trial or at the time of appeal. So what are the provisions which is mentioned in the new amendment with respect to the interim compensation, and we will also discuss about the latest judgment which is pronounced by the Supreme Court with reference to the interim compensation. What are the factors to be considered by the lower court in deciding the application for interim compensation? What are the factors to be considered by the appellate court when the appeal is pending with reference to interim compensation are all discussed in this video. Previously, there is no such provision for interim compensation. This Negotiable Instruments Act was amended. A new amendment came into force in around 2018, in which a new provisions called 143A and 148 and including 143 were inserted. Regarding 143 is a provision which gives the power of the court to try the cases summarily. As far as the check bouncing case is a summons case. Actually, when you go through the criminal procedure code, the cases are classified into two categories. One is called summons case and one is called warrant case. Summons cases are the cases where the punishment is below punishment. The maximum punishment shall be up to 2 years of imprisonment. If the punishment goes beyond 2 years, then it will be called as a warrant case. As far as the check bouncing case is concerned, the maximum imprisonment permissible under the 138 of the Negotiable Instruments Act is 2 years of imprisonment. So this is a summons case. But the new provisions, namely Section 143, empowers the court to try this 138 case as a summary case. Like that, if the court decided to conduct this case as a summary case, it can avoid certain procedures and they can summarily decide the court and speedily dispose the case. Such power is given under Section 143 of the Negotiable Instruments Act through the new amendment which came into force 1/9/2018. So the Section 143 to 147 were inserted by Act number 15 of 2002, but Act number regarding this amendment were inserted by Act number 20 of 2018, which will come into effect with effect from 1/9/2018. So this Section 143 empowers the court to decide as on the Section 138 case in a summary manner. So regarding 143A gives the power to the court to award interim compensation, which means that once the case is filed, the complainant can file a petition to direct seeking the court to direct the accused to pay interim compensation. Assuming for a moment the check case was issued for a sum of rupees 10 lakhs, the complainant can file a petition and the court may seeking the court to direct the accused to pay interim compensation. The maximum amount which can be awarded can be directed to pay shall be 20% of the check amount. So in the case if the check is for 10 lakhs, the court may award interim compensation up to 2 lakhs and the court may direct the accused to pay this amount. So once the petition is filed by the complainant seeking the direction of the court, then the accused can file a counter and the court will decide how much is the amount to be paid. Then the court, then the accused has to pay the amount. So, with reference to this case, with reference to this aspect, this matter was brought to the brought to the notice of the Supreme Court. In the Supreme Court, in the latest judgment, which is reported in 2024 3 SCR 438 at page number 438, which is equivalent to 2024 INSC page number 205, in a case called as Rakesh Rajan Srivatsava versus State of Jharkhand and another, in criminal appeal number 741 of 2024. The Honorable Justice, Supreme Court Justice Abhay S. Oka and Justice Ujjal Bhujan JJ Division Bench delivered a judgment on March 15, 2024. So in this case, the court decided the interim compensation issues, and the court has issued various directions how this case has to be, when a petition is filed for interim compensation, how the case has to be tried, what are the factors to be decided, what are the procedure to be followed, what are the things which is to be considered by the court, are all discussed in this judgment. And the court itself has given specific directions to the lower court to follow all such directions, all such procedures stipulated in this judgment. So as far as this fact of the case is concerned, this the amount involved in this case is more than crores of rupees. An interim application was filed. The lower court directed the accused to pay 10 lakhs, deposit 10 lakhs rupees as interim compensation, against which the accused preferred an appeal. The appellate courts also confirmed the lower court judgment, against which they preferred appeal revision to High Court. High Court also confirmed the same. As against the High Court order, they brought the matter to the Supreme Court. So now the Supreme Court, while deciding this application, deciding this case, has considered various aspects. Regarding the section 143A of the power of the Act, the court the Act has used the word may. So I will read the section, section 143A, which says that notwithstanding anything contained in the Code of Criminal Procedure Code, the court trying the offence under section 138 may order the drawer of the cheque to pay interim compensation. So the word used in this section is may. So here it says that the court may order the drawer to pay compensation. So the wording used in this this section is the court may order the drawer of the cheque issued to pay compensation. So in this case, the argument was put forward by the complainant as if the word may used in this section should be considered as the court shall or court must. So if the words shall or must is used in this section, then it will become a mandatory. So the argument was put forward by the complainant as well as the accused whether the section should be considered as a mandatory provision or is a directory provision. Mandatory provision means compulsory. So whether this section compulsorily says that the interim compensation should be avoided, or it simply gives a direction and gives a discretion to the court whether to avoid, whether to make any direction or to give any relief. So that's when the matter came to the Supreme Court. The Supreme Court considered that this provision is not a mandatory provision. It is only a directory provision. The court said that you cannot interpret the section as if the court shall order, or we cannot say that the court should order, or the court must order, or court shall order. We will only consider that it is not a mandatory provision. The court has the discretion to award interim compensation So the word used in the section may shall only mean the court has a discretion to decide this application. So, in considering the Supreme Court has ruled out that this provision is only it's not a mandatory, and so it is not compulsory on the part of the court to make automatic order. The court may apply its mind, and the court may exercise its discretion, and the court should follow certain rules and regulations that was specified in section 16 in para 16 of the judgment. The court has specified what are the two things to be followed in deciding this application, and in the final para, that is in para 19, the court has clearly mentioned all the things, all the factors, all the procedures which has to be followed in deciding the application for interim compensation. So in first the case said in para 19A, the court said that in the exercise of the power under subsection 1 of section 143 is discretionary. It is not mandatory. The provision is directory and not mandatory. The word may used in this provision cannot be construed as shall. So this is the first observation mentioned in the judgment. The second observation is that while deciding the prayer made under section 143A, the court must record reasons indicating the consideration of all relevant factors. So when the application is filed, the court should consider all the relevant factors. The court cannot automatically order for interim compensation. Then the third thing is the broad parameters for exercising the discretion under are as follows, like what it was mentioned. Number 1, the court shall have to prima facie evaluate the merits of the case made out by the complainant and the merits of the defense pleaded by the accused in reply to the application. The final distress of the accused can also be considered. So these are all things. The prima facie case of the complainant, the defense raised by the accused, and the financial position of the accused are all should be considered by the court. Then the direction to pay the interim compensation only if the complainant makes out a prima facie case. So once if the complainant establishes a prima facie case, then only the court should order for interim compensation. If the defense of the accused is found to be prima facie plausible, the court may exercise discretion in refusing to grant. So supposing the accused established his case, he has a good defense, then the court should refuse to order for interim compensation. The fourth one is if the court concludes that the case is made out to grant compensation, it will have to apply its mind and to the quantum of interim compensation to be granted. So the court will have to consider several factors such as the nature of the transaction, relationship between the accused and the complainant. So once the court decides that interim compensation should be avoided, the court cannot automatically order to pay 20% of the check amount. In deciding the amount also, the court should apply its mind and should apply in applying the mind, the court should consider the relationship between the parties, the nature of the transaction, and the nature and the financial position of the accused. All these facts should be considered while fixing the quantum of amount. The last one is the court the several other relevant factors in the particular facts given. If there are various other factors, so the court said that these factors alone is not a list of the things. If any other factors or any other relevant factors are there, that factors should also be considered, like what the judgment was mentioned. So this is the gist of the judgment. So these are the procedures, these are the observations of the Supreme Court in deciding interim compensation. So now you will be asking, supposing the court decide to order for interim compensation, what will be the next remedy if supposing the accused refuse to pay the amount? So the further thing, the act, the section itself has mentioned that it can be recoverable. It can be the complainant can recover the amount as if like a fine. The court said that supposing the court order to pay interim compensation, the court should give time for 60 days. If the accused did not pay the amount for within 60 days, then they can get another extension of time of 30 days. Even if it is not paid within that 90 days, then the complainant can file a petition, and the amount which is fixed as an interim directed by the court to is not paid, then the court it can be recovered from the accused as if it is a fine. Assuming for a moment the court awarded a fine to any accused, and if it is not paid, then the court has that amount can be recovered by following the procedure and mentioned in section 421 of the CRPC. In such cases, the movable properties of the accused can be attached and can be sold, and from the sale proceeds the complainant that amount can be recovered, or the court can direct the collector to attach the movables or attach the immovable properties of the accused and recover the amount. So that is the procedure is mentioned in the act. So that procedure will be followed. Now you will be asking one question. Suppose the court, if you accused paid the interim compensation amount and finally conducted the case and kindly win the case, and suppose the checkpointing case itself dismissed, what will happen? What will happen about the interim deposit? For that also the answer is there in the section itself. If the court is dismissed, then the complainant has to return the amount collected as interim compensation with bank interest. So suppose the complainant failed to pay the amount, then that amount can be recovered from the complainant as if it's a fine, or as if it is the same procedure mentioned in section 441 can be followed. The amount which is received by the complainant can be recovered as if it is a fine from the court or through the collector's orders by way of attachment and sale of the properties of the complainant. So regarding these are the provisions with respect to the interim compensation and the power of the court to direct interim compensation mentioned under 143A. Regarding 148, that gives the power of the appellate court to order payment pending appeal against the conviction. Supposing the conviction is ordered as against the conviction, the accused preferred an appeal, and when the matter is pending in the appellate court, in that case also the complainant can file a petition before the appellate court to direct the accused to make compensation. So that will be another 20% of the appellate court may order up to another 20% of the check amount. So you may be asking one question. Supposing the interim compensation is paid in the trial court itself, should we pay another interim compensation? Like what you may be asking a question. But as per the section is section 148 is concerned, it specifically says that it is separate. Even if interim compensation is paid in the to some 20% or 10%, 20% compensation paid in trial court as per section 143A, the complainant can seek another 20% separately during the pendency of the appeal, like what this section 148 of the NI Act specifies. So I hope this will be useful to the complainant as well as the accused who are complainant to the accused as well as the accused who are in facing the criminal proceedings or checkbouncing cases. Ladies and gentlemen, you may watch my videos. I have two channels, Razyak Law Tube and Razyak Sattam Arivom. Through these videos, you can enrich your law knowledge. You can clarify all your doubts. In addition to that, if you have any specific doubts or clarification, you may contact me. I will help you. I will give you necessary legal consultation or advice to clarify your doubts depending upon your time and depending upon my time and availability. I hope this will be useful to you. I will come again with another topic. Until then, goodbye. Razia Kali.